Good morning, everyone. Welcome to today's class. I'm your facilitator for today for me, Ohana. As you can see, the what we'll be treating today is business law. Business law, we under business law, we'll be discussing registration of business and compliance requirements. So registration of business and compliance requirements. That's the our business of the day. So what do we expect participants to learn today? We expect participants to have a basic understanding of the nature of the legal system in Nigeria. That is, by the time we are done, we are expecting all the participants to have a basic knowledge of how the Nigerian legal system works to enable participants understand the legal regime and regulatory agencies regulating businesses in Nigeria. So by the time we are done with this today's course, you get to you get to learn the legal regime and what regulatory agencies are regulating business. I know most of you are aware of some of these regulatory agencies, but we'll just talk about them for you to have any understanding. And at the end of the lecture, if you have any contribution question, you can make your contributions or questions to the class. Then for participants to know the types of business organizations and steps in the formation and registration of businesses in Nigeria is also one of the objectives. What we want participants, I expect the participants to learn at the end of this class. Then they understand the basic nature and elements in a commercial contract. So by the time we are done with today's class, these are the things I expect participants to have an understanding of. Then we have what are the topics that we will discuss today? The topics that we'll be discussing today are the Nigerian legal system, relevant government agencies regulating businesses in Nigeria. As you can see, there's a nexus between uh, the objectives and the topics we are to learn. So you see, if we're talking about Nigerian legal system, you get to have an understanding of what the Nigerian legal system is. When we talk about the relevant government agencies regulating businesses in Nigeria, you also get to know about that, the types of business organization and legal implication of the various types of business organization, registration of the business organization, and finally we'll discuss the law of contract. When we come to types of business and legal implication, you get to have an understanding of what kind of business you are running. If your company is not registered yet, if your company is registered or your business is registered, you will get to know this is the kind of thing you are running. If you are about to register, you get to know whether to register a company or a business name. By the time we are done with types of business organization, then we will learn how to do registration of business organizations with the Corporate Affairs Commission. And finally, we'll discuss the law of contract. So, uh, our first topic is the Nigerian legal system. When we say the Nigerian legal system, in this sense, and for the purpose of this class, and even in the wider society, it consists of the totality of laws or legal rules and legal machinery which is obtained within Nigeria as a sovereign country. So it consists, when we say the Nigerian legal system, we're talking about the laws, that's the constitution, the penal code, the criminal code, the administration of criminal justice, the laws of the federation, which comprises of karma, uh, advanced fee fraud act, uh, so many stamp duty acts, all the laws. If you know all the laws contained in the laws of the Federation of Nigeria, so this is what we are going to be looking at. That is the Nigerian legal system. Those laws form part of the Nigerian legal system, which I called like karma, penal code, criminal code, administration of criminal justice. All these are laws, they are part of the Nigerian legal system. Then we talk about the legal machinery. the legal machinery, these laws can't exist in vacuum. There must be people that will enforce them. That's why we have the courts, the police, the EFCC, the lawyers in public and private practice, that we have road safety, we have the FIRS. So all these are there. All these 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 institutions and laws are part of the Nigerian legal system. This combination of these various laws, the institutions that are there to enforce them, the court, the government, all they are there to ensure that the law works for everybody, and that forms part of the Nigerian legal system. So when we are talking about the Nigerian legal system, we're talking about the laws, we're talking about the courts, we're talking about the enforcement agencies, we are also talking about government. The enforcement agencies too are part of government. They also form part of the executive arm of the government. Then we talk about the judiciary, and we talk about the legislative arm of the government. So the next thing we'll look at is the meaning of law. And everybody knows what law is. You might not know it in a complex term, but in simplest term, you can say what law is. Definitely is there to govern a particular people in a particular locality or society. We are part of a family. We are either part of a family or a society or a community or a state. And from if we start from the family, we'll see that families have different rules and regulation regulating how the behaviors of members of that particular family should be. So that is a law in place to ensure that things are done properly, to ensure that the rights of others are respected and not infringed upon by another person. So when we have these laws, they are there to ensure they're there to ensure that law is there to ensure that we do things in an orderly manner. So, as you can see on the slide, it's written that the concept of law may be different things to different people, but to a lawyer and the law profession is more interested in the narrow and guarded meaning of law as a rule of human conduct, tacitly or formally accepted by a people as binding and backed up by some mechanism for sustenance of its binding nature. As I said, is a rule of human conduct, tacitly or formally accepted. So for a law to be of effect in any society, it must be formally accepted by the people of that particular society. For instance, we Nigerians agree that the constitution shall be the ground norm of the land. That is, the constitution is the ultimate. The constitution is the source at which we get other laws in Nigeria. And if you check the preamble to the constitution, you see where they said we the people of Nigeria have agreed that so that means that if you are in Nigeria and you are a Nigerian, you've formally accepted that that constitution should govern you. So any act of dissent will be climbed down by government, because by that provision of constitution, a legitimate government has been elected into office and recognized by the constitution. So whatever that government does is legitimate because it has the backing of the law, it has the backing of the constitution, and is formally accepted by the people as binding. So any government in place now in Nigeria, be it the federal government, be it the state governors, be it the president, the vice, they're acting based on the legitimacy that is given to them by the constitution. And the constitution is in code what the people agreed. That means the people have agreed that the people of Nigeria that constitution shall be binding on everybody. So that constitution gives the government that legitimacy to take whatever action it thinks is in the best interest of the nation. and and it must be backed up by some mechanism for the sustenance of its binding nature. What are those mechanisms we have in place? That's why we have the government. We have the government in place. The government is there to ensure that the sustenance of this binding, the constitution is binding on all of us. So that's why where there are dissent, you will see the government is there to ensure that people are are living their lives in accordance with the provision of the Constitution of Nigeria. That is why there is a provision that says any provision in the any law that is contrary to the provision of the Constitution, I guess is the section 1 of the Constitution, the supremacy clause, which gives the Constitution, that particular law will be regarded as null and void because the Constitution is the ultimate. So these mechanisms to enforce, because these laws cannot exist in vacuum, there must be people to enforce the law. If you make a law in your house and there is nobody to enforce the law, then there is a problem. For instance, in your house, you as the head of the house, if you're a father or the mother, you are the enforcer of the law. So in this place, you are the mechanism that will ensure the sustenance of the binding nature of that law. So also in Nigeria, we have the executive arm of government, we have the judiciary and the legislative arm of government. They are there to ensure that this law is obeyed by people. Then that's it about law. Then we move to sources of Nigerian laws. How the laws in Nigeria did not just fall from the sky. We got them either from Britain or after independence when we started making our own laws and some of our customary laws that are still in place. This these are the sources of the Nigerian law. So we're going to talk about common law first. When we say common law is part of the England law. It's part of England law that was developed. It was from later developed and administered by the old common law in England. That's why it's known as the common law. And how back then in England there was nothing like common law. There was no law that is common to all the people of England. So what happened then? King Henry then those back then in England, that is before the Norman conquest and during the reign of King Henry, what happened was that he sent out itinerant justices. Itinerant justices go to the various communities in England to administer justice. So once they administer justice, they will come back to the crown, that is the capital, and sit down and deliberate on the customs they encountered. So all these customs they encounter, they will discuss and say, okay, this custom of these people is good. So we are going to use it in administering justice in another place. This custom of these people is good to settle this matter. So we are going to use it in settling dispute of such nature in other localities. So as a result, evolved a common law. So that was how they came about common law in England. So you see, customs that are good in different area, they put them together and they have common law administered based on the customs of the realm. So that was how the common law evolved in England. So this common law that evolved in England while we were being colonized by the English people, we received this law into our laws. So that's why some of the laws we still have in Nigeria is still part of the English law that we received during while we were being colonized by the English people. That's why the received English law, we have the received English law, which forms the common law and doctrine of equity. These are laws we received from England and they form parts of our law. Then eventually in England, this is a little bit of history we are doing here. In England, the common law became more concerned with procedure and rather than administering justice to litigants. So the procedure the common law became concerned about form and procedure. For instance, now, if the common law says every agreement, every agreement in Nigeria must be in writing, then you decide to do an agreement and it's not in writing. Common law, even though the agreement is to your favor, because you fail to put that in writing, common law would not recognize that agreement because common law is all about form and procedure. It's not concerned about administering justice. So once you fail to meet that guide, that rule that said it must be in writing, common law will not consider anything, whether it's your right or not. So that was what was happening in England back then. So people became dissatisfied that but I have a right here just because I failed to put it in writing, or just because I failed to do this. So does that so I shouldn't be given my right based on the fact that I failed to put the agreement in writing. People became dissatisfied. As a result, it the doctrine of equity in England came to being. That is why doctrine of equity in this instance is not equity as in fairness, rather equity as in as a law developed by the Court of Chancery to mitigate the harshness of common law. So in England back then, when litigants became dissatisfied with the fact that how can I have a right to something, and based on the fact that I failed to put it in writing, that's why I will not be given such thing. So such people will petition the crown. That is, they will petition the king or queen, depending on who was on the throne back then. So they will petition the crown, and the King's Council, which was comprising of the Chancellor back then, will listen to such petition. And the Chancellor was a priest. So whatever decision he would take back then, the background, that priestly background, will always play a part. So when litigants that are dissatisfied with the decisions of the common law court will petition the crown, and the people that will listen to is the King's Council. So whatever decision was reached out by the King's Council becomes the decision. So as a result, doctrine of equity was evolved, and the doctrine of equity is there to mitigate the harshness of the common law. That's why it's common. Even now, you hear maxims like he who comes to equity must come with clean hand, he who seeks equity must do equity. So these are things that were developed far back in England that are still applicable in our laws in Nigeria. We have received we have received such laws into our own law in Nigeria. Then another source of the Nigerian law is the Nigerian legislation. The Nigerian legislation basically are laws made by the National Assembly or the House of Assembly of various states. We know that it's common for National Assembly to deliberate on bills. So you see them talking that okay, there's first reading, second reading. These are laws. That's why some of our laws, like our Companies Allied Matters Act of 2020, are examples of laws that are enacted by our House of Assembly, by the National Assembly. The CBN Act of 2007 are example of acts that are enacted because they look at the situations that are peculiar to us. What do we need to address? Laws are there to address problems. So once we have them there, they will say, okay, we need to come up with this law to address this particular problem, to address this particular mischief. So they will sit down, deliberate on it, then pass it into law. The president will assent to it, then it becomes law. Example of such, as I said, is the CAMA, the CBN Act, the FIRS Act of 2007, the AMCON Act of 2010. These are examples of legislations that were enacted by the National Assembly. When you go down to the states, you see the states to have their various laws, because some of the laws we have at federal level, if the states do not enact theirs, they are not of effect. So the laws too, you go down to the states, you see states have their own peculiar laws too that are peculiar to their own circumstances. Now we have the customary law. The fact that we received the English law doesn't mean that the customary law back then wasn't applicable in Nigeria or it was totally abolished. Because even at present now, the courts in Nigeria are still applying customary law. That's why you see we have the customary courts, customary court of appeal. You see we have customary issues going to court of appeal up to Supreme Court. Just like the English received law, like we talked of the common law in England, which is the custom laws that are based on the custom of the people of England. So is our customary law, which is based on the custom of the people of Nigeria. But our own customary law has not been codified as in the case of the English people, but it's still applicable. Example of a notorious customary law in Nigeria is the Benin customary law of inheritance, which they said the eldest son, okay, the son is entitled to the eldest son is entitled to his father's residence at the time of his death. So that Benin customary law is notorious in Nigeria, that once it goes to the Supreme Court, you don't even need to do anything. It's judicially noticed. Somebody's writing on this line. Is is judicially noticed. So as a result, our customary law is applicable. Then we have what we call judicial precedent and case law. Judicial precedent and case law are also part of our laws. How do we come about judicial precedent and case laws? Once a law is enacted by the National Assembly or any House of Assembly of any state, these laws are subject to interpretation by the courts. Let's say there is an issue regarding a particular section of the law. Let's say the CAMA that was recently signed into law by the president 2020. Let's say there are problems of interpretation. Maybe CAC is finding it difficult to interpret a particular section and somebody took them to court. So that decision of court interpreting that particular section now becomes a law. So that's why if you go to court, you hear lawyers citing in the case of so versus so, the court decides that. So those decisions of court interpreting that legislation or interpreting a particular section of that legislation becomes a law. And there's what we call hierarchy of courts, which we'll talk about subsequently, but I need to bring it in to explain something here, which is the judicial precedent. When the Supreme Court decides on a matter, it becomes binding on lower courts. So that's why we have the judicial precedent. So when I'm talking about hierarchy of courts, I'll still talk about this judicial precedent so that you get to understand judicial precedents. Then we have international law. There is no doubt that some of the laws we have in Nigeria are laws we domesticated, because by the provision of Section 12 of the Constitution, it says all international laws, for them to have effect in Nigeria, they must be domesticated. So international law like treaties, conventions, these international laws are there to guide the relationship between countries. So some of these, like for instance, the example of law that has been domesticated in Nigeria is the United Nations Declaration of Human Rights, the African Charter on Human Rights. These are things that if you go to our chapter 4, you will see them in chapter 4 of the Constitution. And these are things that are part of international laws that we've domesticated, and there are others. Then hierarchy of the Nigerian courts. When we are talking of hierarchy on the Nigerian courts, the apex court of the land is the Supreme Court. That is the final court. So once the Supreme Court in Nigeria decides on a matter, it becomes final. Other courts in Nigeria, as far as you are not the Supreme Court in Nigeria, even the Supreme Court itself, if that decision is passed, it becomes final and it becomes binding on other courts. So the Court of Appeal, Federal High Court, State High Courts, National Industrial Courts must follow that decision of the Supreme Court on that particular matter. So that's this where the precedent and comes to play, judicial precedent. So once the Supreme Court decides on a matter as the highest court of the land, other courts which are lower to the Supreme Court, once they come across similar issue, they must decide the same way the Supreme Court decides that matter. Then the next to the Supreme Court is the Court of Appeal. As the name implies, Court of Appeal, all appeals from Federal High Courts, State High Courts, National Industrial Courts, Sharia Courts, Customary Courts, from Federal High Court, Courts of Superior Records goes to the Court of Appeal. For instance, let me give you an example of how this thing works. Let's use the Imo governorship uh, election tribunal as an example of decision of the Supreme Court becoming final. At the after the election tribunal delivered a judgment, the party that is aggrieved went to the Court of Appeal. From the Court of Appeal, the judgment was still against the party. It went to the Supreme Court. So the Supreme Court, in its wisdom, decided that APC should be made, the candidate of the APC should be made the governor of Imo State. And you see, that decision by Supreme Court became final. There is nobody that can oppose that decision, and it has become the law. So when similar issues, except the Supreme Court on its own decides to deviate from that decision, then we'll say there is a change of law. So that's how the hierarchy of courts work in Nigeria. We have the Federal High Court. The Federal High Court used to be a revenue court in Nigeria. It's established by Section 251 of the 1999 Constitution, and that section listed out matters that can be but that can be heard by the Federal High Court. So when you go to your Section 251 of the Constitution, you see matters that can be entertained by the Federal High Court. Then we have the State High Courts. The State High Courts have unlimited jurisdiction on criminal and civil matters, with the exception of matters that fall within the purview of the Federal High Court. So these are courts we find in the state, and they administer the laws of that state to the entertain matters on issues relating to law of that state. And we also have the state high court and the FCT high court. They are all of coordinate jurisdiction. They are together. That means if that court decide a matter, if a state high court decide a matter, you cannot say you want to take the matter to another state high court. Rather, you appeal to the court of appeal. So you see, all these courts are courts of coordinate jurisdiction. That is the Federal High Court, State High Court, and National Industrial Court. And they don't entertain similar matters, except though there are exceptions like matters of fundamental rights. You can take it to Federal High Court, you can take it to State High Court. Then when we talk about National Industrial Court, when we talk of the National Industrial Court, the court is established for the purpose of entertaining matters relating to trade unions, labor matters, employee master servant relationship. So this court has the exclusive jurisdiction to entertain such matters. Once judgment is given against the party and is not satisfied with the judgment, he can appeal to the court of appeal. We have the Sharia courts. We have the Sharia courts are there to entertain matters relating to Islamic law. So once parties are subject to personal Islamic law, so are subject to Islamic law, they can subject themselves to Sharia courts. If you go to some states, you see the Sharia courts are of grades, and you have the Sharia Court of Appeal. So decisions of the Sharia Court of Appeal in some states goes to the Court of Appeal. From the Court of Appeal, it goes to the Supreme Court. Then we have the customary court. As the customary court is there to entertain matters relating to the customs and tradition of the people of that particular locality. That's why the judges in such courts must be people that are braced with the tradition and customs of the people. Then we have the magistrate court. The magistrate court has jurisdiction to entertain civil and criminal matters, but it has limited jurisdiction, as not all subject matter that can be entertained by the magistrate court, because by virtue of its jurisdiction, it cannot entertain certain subjects. For instance, you cannot take land matters that which titles are contended to the magistrate court, because it doesn't have that jurisdiction. Then we have the area courts. The area courts are customary courts too. It's just no change of nomenclature. In the north, they refer to them as area courts. But when you go to the south, mostly it's customary courts. So they also administer the custom and traditions of people. Then we have the civil law. When we talk of civil law now, we are talking of of laws that are there to regulate the conduct of person in their interpersonal dealings with others. So civil laws are there to regulate um, um, the conduct of persons in their interpersonal dealings with each other. Mostly common civil laws are not statutory. That means you cannot find them written in a law, but based on the decisions of court and principles of 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 cases that have been decided. So you get to know that okay, transfers and the rest, but you have like Sales of Goods Act is there to guide uh, uh, things that have to do with buying and selling. So though most of the time civil laws are not there to are not statutory. That means they are not you cannot found you cannot find such in a law that is coded in a book or something that this is civil law for you to be opening and be checking your rights and all. But it confers status, rights, and obligation on individual or juristic persons like companies and the rest. So that's civil law for you, like things like defamation. Like somebody says, writes something about you on a print that's libel and you feel it's not right, you can sue that person. You are enforcing your right because that's that person has an obligation towards you not to slander you. So when once he does that, you have a right to go to court to enforce your right. We have trespass. Trespass is when you have an exclusive possession of a property, be it you're renting it or it's yours. There's this presumption that you have an exclusive possession. So once somebody is trying to trespass on that your right, then it becomes a problem. So you can go to court and enforce that particular right. Battery, which is attempting to beat somebody and the rest. All these are examples of civil law. Then we have the Nigerian criminal justice system. When we are talking of the criminal law or the criminal justice system, basically it relates to crime. It proscribes conduct perceived as threatening, harmful, or otherwise endangering uh, to the property, health, safety, and moral welfare of all citizens. So you see, criminal law is there to protect citizens, and normally criminal law is statutory. That means you see a law written that this is how if you do and this is the punishment. If you see, and it's once you commit such laws that are statutory, you are committing it against the state, and it will be considered as a crime. So it involves the enforcement of those rules of conduct, usually statutory. That is why Section 35 sub 11 of the Constitution says that for somebody to be punished for an offense, that offense must be defined. You get it? That offense must be defined and punishment prescribed. And the penalty is prescribed in a written law. If not, that person cannot be punished. That's why. So criminal law is there to guide your conduct towards others too. But such conducts are statutory. So once you that conduct is contrary to one of the status, one of the things written down in the law, they will bring it out to you that that is why if you go to court, if I don't know whether some of you were privileged to go to court, if it is a criminal matter, the first thing you see is normally you see so person against the state, against federal government of Nigeria, especially when it has to do with murder, or you see forgery or money laundering, you see person against the EFCC, even though he committed that fraud against a person. But once you lodge a complaint with the EFCC will take it on behalf of the government, because that particular conduct is statutory and it might is harmful to the society. So there is need to protect such. So that's we've discussed at length the basic things you need to know about the Nigerian legal system. So I believe now, if you're asked any question on the Nigerian legal system, I don't expect you to have a broad knowledge, because all these things we discussed are topics on their own. But at least you have to have a basic idea of what the Nigerian legal system is about. So the next thing we're going to look at is the relevant regulatory agencies. What are the relevant regulatory agencies regulating businesses in Nigeria? So first of all, we have the Corporate Affairs Commission. The Corporate Affairs Commission, which we will look at later in
Join
detail.
the meeting.
We have the Federal Inland Revenue Service and the various states' internal revenue services. We'll look at those ones too in detail later, especially the Federal Inland Revenue Service. Then we have the Central Bank of Nigeria. The Central Bank of Nigeria is the apex regulatory financial institution in Nigeria. It's the apex financial institution in Nigeria. Is there to regulate banking in Nigeria and to roll out general policies for the growth of the Nigerian economy. I think it was last month that that the CBN reduced the lending rates in Nigeria, I guess, to 11%. So these are kind of policies put in place by CBN for the purpose of ensuring that the Nigerian economy keeps growing and the rest. So, and the CBN is also there to regulate the financial institution. That is why we have the both here, the Bank and Other Financial Institution Act, which is administered by the CBN. And the CBN was established by the 1958 Act of the CBN, but the current legal framework for the CBN is the CBN Act of 2007, together with both the Bank and Other Financial Institutions Act, which is also administered by CBN. So this CBN is there to ensure that banks banking is done in the proper way, and we have laws that are there put in place. So for every bank, the CBN is there to monitor to ensure that that bank is doing its job uh, um, correctly. Then we have the Asset Management Corporation of Nigeria. The Asset Management Corporation of Nigeria was established by the AMCON Act of 2010, but the act has been amended in 2019 to effect certain changes. Basically, AMCON is there to ensure liquidity flow in the Nigerian banking system. That means AMCON is there to ensure that once there is a non-performing loan in the bank, it will buy off that loan from that bank and go after the debtors itself. So by doing that, the AMCON is ensuring the flow of cash within the Nigerian banking system. For instance, let me give you an example of AMCON how AMCON plays its part in the Nigerian uh, financial institution. For instance, a company goes to GT Bank and borrows money from GT Bank, let's say 20 million. Agreement has been reached, everything reached. This is how they repay the loan. But eventually, the company begins defaulting in the payment. So as a result of that defaultment, that particular debt becomes toxic to the bank because the person is not paying as he should, and that will affect the flow of cash for others to come and say they want to borrow money from that bank. That failure of that company to repay back that loan is affecting the flow of cash. So what AMCOM will do in this instance, it will come and meet the bank. Do you have any non-performing loans? Do you have any toxic loans that we can manage, we can buy off from you? So what AMCOM will do, AMCOM will normally buy off that loan from that bank, and they'll pay that 20 million naira that company borrowed from the bank. So so doing now, and the bank is no longer indebted to that company. So the bank is now indebted to AMCOM. And what AMCOM will do now, AMCOM will go after that company to recover that money. So that's the function of AMCOM. Then we have the National Agency for Food and Drug Administration Control, which we'll also discuss that in detail. Then we have the Standard Organization of Nigeria. We'll also look at that subsequently. Then the Federal Capital Development Territory and the State Commissioner for Lands Local Government Council. So if any business you want to do relates to land and you are within the FCT, the appropriate agency to approach is the FCDA or the AGs under the FCDA, whatever land dealings you want to do. Or if you're in another state, in that particular state, you go to their land ministry or you go to any agency that's established for the purpose of allocating land and the rest. So we're going to look at some of these agencies that I said we'll discuss in detail. So one of them is Corporate Affairs Commission. Corporate Affairs Commission was established by the Companies and Allied Matters Act of 1990. So the CALMA and CAC are one and the same. The CAC is there to administer CAMA. So that's why it is the regulatory agency in charge of registration and regulation of business and non-business organizations, such as companies, business name, and incorporated trustees. So if you want to register your business or non-business organizations uh, like NGOs, churches, mosques, is the responsibility of the CAC. The CAC will take care of that for you. That's why we have the Corporate Affairs Commission. And by virtue of Section 7 Sub 1 of the CAMA 2020 as amended, it sets out the main functions of CAC to include regulation, supervision of the formation, incorporation, management, and winding up of companies, and maintain a company's registry in all states of the federation. Regulation, after you've incorporated your company with CAC, it will have to regulate, because there are certain filings you will have to do with CAC after you've incorporated your company, like filing annual returns, business name, ITs, uh, need to file their annual returns every year. This is to show CAC that your business is a going concern. So incorporation at the incorporation, if you want to incorporate your business, you go to CAC. We'll talk about incorporation later in details. Then you have the management. The CAC does the management of those companies. Sometimes they take over management of a company after investigation. So then you have winding up. When your business is no longer a going concern, you feel you don't want to run the business anymore, you can apply to CAC to wind up that company. Then it maintain a company's registry. That is, for every company register, CAC has it has a file for that company. So if you want to change your directors, you want to change shareholders, you want to bring in new proprietors, you want to change the object of the business or the nature of the business, you need to file some documents at CAC. So those documents that are filed will be kept in your file with the CAC. That's the registry maintained by CAC. Then it has the power to carry out investigation into the affairs of the company if the situation demands. Such situation will arise when that company, that church, that business is not carrying out its business according to the objects. Because by the time you are registering your business with CAC, you list out your objects, that this is what we intend to use this particular organization we are registering. So by the time you begin to deviate and CAC investigates and discovers that you are beginning to deviate from your object, CAC is empowered by CAMA to file an action in court, where parties will be heard. Court is not an automatic thing; it has to be by an order of court. So once court gives an order that that particular company can be taken over by CAC, CAC will take over the management of that company. That's why this present CAMA 20 has generated a lot of controversy, because churches are saying, how can they empower CAC to take over a church, to appoint new trustees to a church when the trustees you get, but it's not an automatic thing. They will have to go to court. Parties, because Section 36 of the Constitution guarantees fair hearing. So parties will have to be heard by the court. The courts are convinced by the case put out by CAC that they should take over the affairs of that company. Then the court can order for such. It's not an automatic thing. Then we have the Federal Inland Revenue Service. The Federal Inland Revenue Service used to be an arm of the Federal Board of Inland Revenue. So it used to be an arm, but after the passage of the 2007 Act, it gave it autonomy from the Federal Board of Inland Revenue. The Federal Board of Inland Revenue is just there to roll out general policies for the FIRS, the Federal Inland Revenue Service. So all existing manufacturers, distributors, importers, suppliers of goods and services are to register with their local VAT offices. So the function, sorry, before we talk about registration with your local VAT office, the Federal Inland Revenue is in charge of the collection and administration of federal and corporate taxes. That is why taxes like VAT, companies income tax, personal income tax, petroleum profit tax, all these are federal tax that are administered and collected by the Federal Inland Revenue. Aside the collection and administration of federal and corporate taxes, it is also the responsibility of the Federal Inland Revenue to administer and control the different tax law, the various tax law we have in Nigeria. So it is their responsibility to also control and administer. Aside that, too, the as those tax law as specified in Schedule 1 of the Act establishing Federal Inland Revenue. Aside from the control and administer, they also administer and enforce the various tax enactments we have in Nigeria. What are these tax enactments? I've mentioned some like the Value Added Tax Act, like the Companies Personal Income Tax Act, the Companies Income Tax Act, the Stamp Duty Act. These are acts that are administered, that are enforced by the Federal Inland Revenue Service. So we are going to concentrate more of on the value added tax, because once you are into a business, you have to remit VAT to to the federal government. And what is this VAT? VAT is just a consumption tax that is levied repeatedly on a product or a service that is offered to you. That is why every time you are buying a particular product, they will be they will, if even though you are buying the product 10 times, that supplier of that product will still be removing VAT. You will have to remove VAT for the purpose of remitting same to the federal government through the local VAT office, which is the Federal Inland Revenue. That is why if you buy products today, if you go to the supermarket, you will see VAT inclusive. I don't know of the open market whether how they charge, but you are supposed to charge for VAT, and the essence of charging for VAT is for the services, for the because VAT means value added tax. So that for the services offered or for the products sold to you, they have to levy a tax on it. So anytime you're buying, for instance, if you make your call now, you will see they will tell you your call is so seconds and it's charged as so rate, and the VAT is so amount. So when you put all this together, you see that for products sold and services offered, VAT has to be included in the final amount to be paid. So for everyone who is going into a business, he has to register with FIRS for the purpose of remitting your VAT. That is why the because there are goods that are vatable. Because not all goods are vatable. When you go to the Finance Act of 2019, I guess you get to see some of these things. So the prospective VAT payer will obtain and complete a VAT form and return it to his nearest VAT office, which is any FIRS office close to you. A permanent VAT registration number is to be given to each registered payer. So you collect the VAT from the customers and you remit it to the federal government through the FIRS. It's not for you to keep it for yourself, it's for the federal government. So that's it on Federal Inland Revenue Service. So we'll talk about the standard organization of Nigeria. For I know you've seen some products levied standard organization of Nigeria. So with the logo standard organization, because standard organization is the sole statutory body that is vested with the responsibility of standardizing and regulating the quality of products in Nigeria. So that's their responsibility. So if you are importing a product into Nigeria or you are locally manufacturing a product into Nigeria, for those products that are within the inventory of Standard Organization of Nigeria, then you must certify such with the Standard Organization of Nigeria. If not, you stand a risk of losing your commodities if they eventually decide to go on inspection in markets and they see that your product is not of standard and you are distributing it or selling it out to consumers, so you stand a chance of seizure, confiscation, destruction of your product because it's substandard. So the functions of this of SON, as you can see on the slide, is one to investigate the quality of facilities, materials, products in Nigeria, and the rest, to ensure reference, standards of calibration, and the rest. As you can see, if you go to compile an inventory of products requiring standardization. So if you go to SON, you get to see what products you need to standardize with Standard Organization of Nigeria, because it's not all products. When we talk of NAFDAC, because those products that fall under the purview of NAFDAC is not for the Standard Organization of Nigeria to certify. It's for NAFDAC to issue a NAFDAC registration number to that effect. So to foster the interest in the recommendation and maintenance of acceptable standards by the industry to register and regulate standard marks, to advise states and federal departments. So these are the functions of of Standard Organization of Nigeria. So how do you register your product with the Standard Organization of Nigeria? So basically, the we'll just a brief look at, because if we say we are going to discuss the procedure of registration with Standard Organization of Nigeria, then we are going to spend the whole day, and we don't have the luxury of time to do that. So I'm just going to give you a brief, and you have an idea. If you want more detail, you could. I will give you some sites you could Google and go to find details on how to register your product with Standard Organization of Nigeria. For instance, now the Standard Organization of Nigeria makes provisions for registration by e-product registration. So you do it e-registration, and there's what they call the MANCAP. Basically, the MANCAP is mandatory conformity assessment program for locally manufactured products. Even for the locally manufactured product, you can still do e-registration. So basically, they have the e-registration and they have the mandatory conformity assessment program. They also have this registration for goods that are shipped into Nigeria. They call that one Standard Organization of Nigeria Conformity Assessment Program for goods shipped into Nigeria. So for that one, let me give you a site that you go to learn about the goods that you need to confirm, you need to standardize with the Standard Organization of Nigeria for the purpose of getting that product certified, especially when you are shipping it into Nigeria. Especially when you are shipping it into Nigeria. You could go to www.cortina.com, check on export guide to Nigeria, or you could just Google export guide to Nigeria. You get to see uh, you get to see you get to see how what are the products that are within the inventory of Standard Organization to certify. So let me repeat the site, www.cortina.com. You could check export guide to Nigeria. So you will see a PDF format of the requirements and the documents all on that site. Is called the Standard Organization of Nigeria Conformity Assessment Program for goods shipped into Nigeria. So the e-registration, you just go to their site. Let's come back to the e-registration. You log in, you register as a as a new company. You enter some details and the rest. So you get to enter your details, the product. You see how you go about registering those products. So once you enter those details, you download. There are some documents they will require from you. Download them, then you upload it back. Let me give you a reference site you can go to to also get a detail on how to go about this registration. You could just Google how do I register my product with the Standard Organization of Nigeria, or you could go to 618biz.com. 618biz as in bees, the bees we .com. How to register your product, because these are things that are so detailed. I said if I say I should discuss them, to take the whole day for us to finish, and we don't have the luxury of time. as time is already against us. So you can go to 618bs.com. You see how do I register my product with the Standard Organization of Nigeria. So all this will give the is in detail. You get to know and you get to see. And if you have any problem, you have the luxury of walking to their head office. If you are within Abuja, is at zone 7 there to make any inquiry physically if you want to. So then we are going to talk about NAVDAC. So you from if we're discussing NAVDAC, you get to see those products that are within the purview that are categories of products for NAVDAC to administer. So Standard Organization of Nigeria cannot certify such products because those are for NAVDAC to certify and mark to certify standard and fit for consumption, not for the Standard Organization of Nigeria. So NAVDAC has the mandate for controlling, maintaining the distribution, advertising, exportation, importation, manufacture, and the registration of categories of products such as foods, drugs, medical devices, and cosmetics, etc. These are things that are categories. These are categories of products that are to be administered by NAFDAC for controlling, maintaining the distribution, advertising, exportation, importation, manufacture, and the registration of the categories of products such as food, drugs, medical devices. So all businesses dealing in food and related products are subject to regulation by NAFTA. So once you want to go into food, water, drugs, medical, cosmetics, these are things that you need to register them with NAFDAC. Upon registration, NAFDAC will issue a NAFDAC registration number to you. So once your product is registered with NAFDAC and so over time due to publicity by NAFDAC and the rest, you need before you buy a particular drug, before you buy a particular product, check if it is food like foods and the rest that are within categories of product that are administered by NAFDAC. You need to check whether it has a NAFDAC registration number, and that has sunk into the people's consciousness. So it's typical for me now. If I want to buy a drug or something, I'll check, is that drug registered with NAFDAC? Even sachet water, where is the NAFDAC registration number? So if you are into categories of products that are administered by NAFDAC, then you need to register your product with NAFDAC, as it is unlawful to market any drugs or consumable goods into the Nigeria without without your NAFDAC registration number. um, Without your NAFDAC registration number. So NAFDAC registered different categories of products. So let's look at these products that are registered by NAFDAC. You see, food and water. If you are into food and water, then you have to register with NAFDAC. Drugs and medical devices, you have to register with NAFDAC. Herbals and cosmetics, you have to register with NAFDAC. If you're into herbal and cosmetics, you have to register. Vaccines and biologics, you have to register. Chemicals, NAFDAC. Veterinary products and narcotics, you have to register with NAFDAC. So once you are into this or you intend to go into this production of this category of products that are administered with NAFDAC, you have to register with NAFDAC. So though the specific documentation vary for different drugs, food categories, when you want to register with NAFDAC, the general registration procedure is similar and broadly is in two-stage process, which is application for approval to bring in samples when you are importing. That is when you are importing, then application for full registration. When some of the drugs, majority of the drugs we have are imported in Nigeria. So before you import them too, you have to apply to NAFDAC that you want to bring samples for them to look at. So you have to bring it to NAFDAC that okay, I have these samples, I want to import this drug. I want you guys to look at this sample. So NAFDAC will look at, then you have application after they look at and they're approved, We'll look at some key requirements subsequently after. Then you do the full application for the registration. So if for details, you can go to the NAFDAC office at Zone 7, but we'll still talk about some of the key requirements that we need to register a drug. We are going to use drugs because we can't discuss all the categories of products. That's why we said for details, you need to contact NAFDAC. So these are things that if you can't do yourself, there are agents around, lawyers are there, and other agents that can help you do such registration. So let's look at the key requirements for registration with, if you want to register drugs with NAFDAC. Let's see what are the key requirements, what are the documents you need to submit to NAFDAC, what are those things that you need to bring for NAFDAC to say, okay, we are going to issue a registration, we are going to register your product and issue you with a registration number. So basically, the requirements here we have on the slides or on these slides are just the major requirements, the key ones you need. It's not everything that is listed out here. As I said, these are things that are like topics on their own. For details, you can go to NAVDAC. You can. They've even begun an online registration, an e-registration. So we'll also look at the e-registration, but in brief too. Then, what are the key requirements if you want to register a drug? Application is on a single product basis. When we say application is on a single product basis, that you can't register, you can't obtain one registration for two different products. Let's say you are producing medication for stomach ache, and then you are you are you are producing a medication for headache, and you make application that both the medicine for the stomach ache and the one for the headache should be issued the same NAFDAC number. It will not be possible because application is on a product on a single product basis. So you have to apply separately for the for the medicine for the headache, separately for the product for the medicine for the stomach ache. You cannot just lump the application and say, I want you to register the two for me. It has to be on a single product basis. The written application stating the name of of the manufacturer and name and brand if applicable, completed NAFDAC application form, certificate of incorporation with the Corporate Affairs Commission if it is a company. If you have a company that wants to go into the production of drugs, then you need to register with the Corporate Affairs Commission. We'll talk about that. Then you need to submit 5 copies of the product dossier. 5 copies of the product dossier to NAFDAC. That when we say 5 copies of the product, we mean the collection of the various documents and data, including data, regulatory documentation, concerning research, development, safety, and efficacy of your licensed product. These are things you need to submit to NAFDAC. 3 packs of the product samples. When you are importing a drug, let's use Pfizer for instance. Let's say Pfizer has a manufacturing plant in India and you intend to import that drug from India. There are some documents you need to certify or you need to get from Pfizer in India for you authorizing you to import that particular drug to Nigeria. So without you getting that document, such document, for instance, power of attorney, and that is authorizing you, that Pfizer is authorizing you to import that drug to Nigeria or to come and manufacture the drug in Nigeria. So that power of attorney is simply a document saying, I am saying Mr. A can act on my behalf. You get it? So what NAFDAC will tell you is you must have that document notarized. Notarization is there's stamp or something of a of either the British High Commission or ECOWAS country mission, or that is in the absence of a Nigerian mission in the country of manufacture. Like for instance, since we're using Pfizer and Pfizer is India and India is a Commonwealth country. So let's say for instance you want to notarize that power of attorney given to you by Pfizer. So if there is no, let's imagine that there is no Nigerian mission in India, which we know there is the Nigerian mission. If okay, first of all, you go to the Nigerian mission to notarize that particular power of attorney given to you by Pfizer in India. If we don't have a Nigerian mission in India, then you can go to any British High Commission or ECOWAS High Commission. They will authorize and authenticate that power of attorney for you, issued to you by Pfizer. So by doing so, if you want to apply to NAFDAC to issue registration or to give you approval or anything for you to import that drug, you will have to attach that particular uh, document and notarized, and it has to be notarized by either the Nigerian mission, ECOWAS mission, British High Commission, anyone you can find in the country which you intend to bring in the drug to Nigeria. In the absence of power of attorney, there can be contract manufacture agreement. So contract manufacture agreement too has to be notarized. This is something you also need to notarize with any of the Nigerian mission or anything. So current certificate of pharmaceutical. So you know now that is not just importation, but we said the distribution of drugs, exportation, distribution, advertising. All is the responsibility of NAFDAC. It's the mandate of NAFDAC to ensure that all these are done in line with the NAFDAC Act. So if pharmacies, if you want to run a pharmacy and the rest too, you need these are there are some things you need to submit to NAFDAC for you to run such pharmacy. You see premises registration license from the Pharmacists Council of Nigeria, certificate of registration of brand name with trademark registry in the Ministry of Commerce, especially for brand names like Pfizer, which is a well-known brand in the world. So if you want to import from them, you must bring in their certificate of registration of their trademark with Ministry of Commerce. In the absence of that, you have to register before. All these are requirements you need to to, to submit, documents you need to submit to NAFDAC for your application to be granted. Then you have letter of invitation from the manufacturer to inspect factory abroad, stating full name and location of plant. When you want to import, you have to get you have to get a letter of invitation from the manufacturer. For instance, Pfizer now in India will give you a letter of invitation inviting NAFDAC to go and inspect their facility or plant in India. So you pay the applicable fee and you'll be issued this thing. So of recent, your certificate, NAFDAC introduced an e-registration system, and NAFDAC called that particular e-registration system as the NAFDAC Automated Product Administration and Monitoring System. For the acronym is NAPAMS. So NAFDAC Automated Product Administration and Monitoring System, NAPAMS. So instead of going to their office to pick up a form, fill the form, you make inquiries, NAFDAC has decided to come up with an e-registration system. So you just go to www.napams.org. Once you enter, you sign up or register an account as a client, as a new person. After signing, you enter you log in. If you are registered, you log in. After you've logged in, you fill in the form. After filling the form, you make payment, completion of payment, you process your certificate. It's not as easy as I'm saying it because I know they just started it of recent. I don't know how efficient it is. And 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 such things are not just like okay, just easy like that, especially when you are not good with IT. You find it very difficult to do such things. So sometimes it's good you meet people that are good with that, or you can go to the NAFDAC office and get enlightened, and you have people that will put you through, assist you, and the rest. So this is it about registration with NAFDAC. As we've seen, the categories of product that can be administered with that are administered by NAFDAC, and the products that can be registered with NAFDAC. We've looked at them. So now we are going to the next topic, which is types of business organization and the legal implication of the various types. So this is very important. You need to so that you need to know what kind of business you run, or if you are running a business already and it's not registered, you get to know, or if you are running a business, you get to know what kind of business you are running and what is the implication of you running that. What's the legal implication? So if today I decide that I want to run sole proprietorship, what's the legal implication? If I say it's partnership I want to run, what's the legal implication? If I say it's company I want to run, what's the legal implication? So when we talk of business organization, we are only talking about a legitimate venture to make profit. You need the keyword there is legitimate. It has to be something legitimate. You can't be doing an illegitimate thing, making profit. That you are not running a business organization, you are running a cartel in a negative way. You are there running an illegitimate uh, something empire business. So a business organization must be a legitimate venture to make profit. What are the types of business organization? As you can see on the slide, we have sole proprietorship, partnership, and company. So we look at sole proprietorship and its implication. So when you say you are a sole proprietor, as the name implies, sole, one person running his business, taking the decision alone, enjoying the profits alone. If he dies, the business dies with him. So in this case, I will be using Johnson Ventures business. Johnson, I will use to do my examples. I will use Johnson Johnson Business Ventures. So let's say Mr. Johnson runs Johnson Business Ventures. So as the sole proprietor of that business, he makes the decision alone. He enjoys his profits alone. He borrows money from the bank in his name, Mr. Johnson. He cannot borrow money in the name of Johnson Business Venture because he's running it as a sole proprietor. And even when such sole proprietorship is registered to CAC, it does not change anything. That sole proprietor is still a sole proprietor and his liabilities are personal. So, what are the legal implications of running a sole proprietorship? First of all, when you die, the business dies with you. That's one of the implications of running a sole proprietorship. You die, the business dies with you. There is no perpetual succession, it dies with you. So if Mr. Johnson says, I'm running Johnson Business Ventures, once he dies, the business dies with him. So, and once you borrow money, your your liabilities are unlimited. Loans, debt, rent, and the rent. You alone will pay it. And the fact that you cannot even borrow in the name, Mr. Johnson cannot even borrow anything in the name of Johnson Business Venture. It has to be in his own personal name, Mr. Johnson. So anytime he defaults and the bank or the person he's owing decides to come after him, he can go after his personal belongings, his car, his house, anything he has in his name. The person can go after him to offset that debt. So that's why we said personal assets like cars, properties of the owner may be seized to offset the debt of the business. So you can see that if you are running a sole proprietorship, the legal implication of such is that you're you're personally liable for all your debts, any liability, you are personally liable. And the fact that you registered with the CAC, as I said earlier, does not create a separate legal personality. You get to know what legal personality is when we discuss companies. The owner's personal asset and the business are separable when it comes to sole proprietorship. Then let's look at partnership. When we're talking of partnership, that means two or more persons come together and decide to run a business with the sole purpose of making profit. So partners must must come together with the purpose of making profit, not just making profit, but with the aim of sharing the profit equally, except they decide otherwise by their agreement. So partnership can be general and it can be limited. You can decide to, if you are running partnership today, you can decide to be a limited partner, you can decide to be general partner. And in the case of general partners, they have unlimited liabilities similar to a sole proprietorship. So when I said I want to be, let's say Mr. Johnson and Mr. John went into a partnership. Mr. John said, this told Mr. Johnson, I don't want to be a general partner. I just want to be a limited partner. A limited partner in the sense that Mr. John is telling Mr. Johnson that I just want to invest. I don't want to be part of the day-to-day running of this business. You get it, of running the business. I just want to invest. So in that case, Mr. John is a limited partner. And the implication of being limited partner is that his risk is limited. Is limited to his investment. You cannot go after his personal belonging. You cannot go after Mr. John's personal belonging to offset a debt that is collected by Mr. Johnson on behalf of the partnership. So Mr. John's liability is limited to his investment in the business. So that's why Mr. John decided to be a limited partner. So now, if you want to go into a business by the partnership agreement which you enter, you can say you want to be a limited partner. Though with the enactment of this KAMA of 2020, we have what we call limited liability partners. It's a partnership in form of a company where the partners are separate from the partnership. So you cannot go after the partners to offset a particular debt. That's why you see some partnership, you see a business carrying LLP, showing you that it's a limited liability partnership. But in this case, we are just limiting ourselves to limited partners and general partners. But in the case of general partners have unlimited liabilities. As we said, general partners are at risk of having their personal belongings seized. So when, on the other hand, if Mr. Johnson and Mr. John come together and said they want to form partnership and they want to go into a business, and Mr. John decides that I want to be involved in the day-to-day running of this business. So in that case, Mr. John has become a general partner. And in that case, when they borrow money in the name of the business, the the company or the bank they are owing, they can come after them personally, personal liabilities and the rest. They will come after them because the business is made up of two, each sharing profits, debts and liabilities and assets when you decide to be a general partner. So general partners are at risk of having their personal belongings seized to offset the debt and liabilities of the partnership business because it's a business made up of two or more partners, each sharing the business debts, liabilities, and assets. But in the case of limited partnership, which exists two or more partners go into business together, but one of the partners are only liable up to the amount of investment. Because in that case, that partner is just a limited partner. So his liabilities is limited to his investment in the business. So when you are going into partnership, it is important for you to agree that you will share the profits equally, except you decide otherwise by your agreement. Because if there is no agreement on ground and Mr. John and Mr. Johnson decides to enter in, Mr. John and Mr. Johnson decide to enter into partnership, and one is just gaining from the profit, or Mr. Johnson is running a business and he calls Mr. John and say, come and join me now, and there is no agreement as to sharing of profit. Mr. John should not consider himself a partner in that business because he does not partake in the sharing of that profit. So as a result, if you are going to enter into any partnership business, you have to settle the issue of sharing profits. You have to partake in sharing the profits, and the profits should be shared. Mostly, it should be shared equally, except parties decide otherwise. Then another, companies. So all this while that we've been talking about partnership, general and limited partnership. In the case of general partners, their liabilities are unlimited. In the case of sole proprietor, your liabilities are unlimited. In the case of limited partnership, is your liability is limited to your investment to the company. So if you are a limited partner or you run a company, it's almost similar because shareholders, directors are not regarded as part and parcel of the company. Because in law, by the time certificate of incorporation is issued to a company, that company becomes a separate legal personality. That's why in law we have what we call artificial and natural persons. Companies are artificial persons because by law they are separate human beings. That is why you see people saying it's the company that borrowed the money. I'm not the one. I'm just a shareholder in the company. Because your shares, be you a shareholder, your liability is limited to the shares in the company, to the shares, your be it 250,000 shares. So your liability is limited to that share. So by as at the time Mr. Johnson, let me use Mr. Johnson, says, okay, I'm tired of running this Johnson business venture. I want to register a company. I want to register Johnson and Johnson Limited. So Johnson and Johnson Limited now will become separate from Mr. John. Immediately, he registers Johnson and Johnson Limited, and the CAC issues a certificate of incorporation to him. Johnson and Johnson Limited is separate from Mr. Johnson. So all those things that he couldn't enjoy, like the banks coming after him personally because uh, he runs a business which is not a separate legal personality. Now he will begin to enjoy such things because he is now separate from that business. Johnson Johnson Limited is an artificial person in law, while Mr. Johnson is a natural person in law. So today, if you decide to register your company, that company is different from you. You and that company are not the same. So anything, if the bank is going to come after that company, is going to come after the company, not you. But there are exceptions to this general rule. In the case of fraud, once you use that company to commit fraud, that is what we call in law lifting the veil. It's a principle where the court will order for the shareholders and the directors in the company to be reviewed because they've committed fraud. So once shareholders of company have limited liabilities, their debt and liabilities of the company is not the debt and liabilities of the shareholders. So let's say Johnson and Johnson Limited incurs a debt from company they borrowed, and in the end they failed to pay that money. So the company going to court getting judgment, it can even sue him. They cannot sue Mr. Johnson in his name. They can only join Mr. Johnson as a party in the case, but the main party, the necessary party in that case will be Johnson and Johnson Limited, because that's the party they entered into the contract with. So we also talk about privity of contract when it comes to privity of contract. So what are the implications of that company as that company is registered now? You see, you can buy and own properties. That's why it's common for you to see some certificate of occupancy carrying name of companies rather than individuals, because these companies are regarded as artificial persons, and as a result they can acquire property, they can enter into contract. Today if you register your company, you, instead of you personally, instead of Mr. Johnson entering the contract in his name, he can decide to enter the contract in the name of that company, or he can sue and be sued. In the case, the company can sue whoever it is indebted to, or whoever it feels breaches its rights, and at the same time the company too can be sued in its own name. So it's vice versa, because that company is an artificial person. Then it enjoys perpetual succession. That means it lives forever. A good example is First Bank. If you check the motto of First Bank, you see since 1959. Are you telling me the people that started the First Bank, the initial shareholders, are still alive? No, but because First Bank is registered as a company, so it enjoys what is called perpetual succession. So today, if Mr. Johnson decides that he doesn't want to be a shareholder in Johnson and Johnson Limited, he could just decide to share. He can just decide to sell his shares in the company, and he disappears from the company. He has no business with the company. So the new shareholders, it's up to them too. If they still want to maintain the name Johnson and Johnson Limited, or because the CAC, the CAMA has made provisions for change of name. So if they want to change the name, they can change the name. If they want to continue with Johnson and Johnson Limited, because of the goodwill and the reputation Johnson and Johnson Limited has built over the years, then they can continue. Nothing will happen. Mr. Johnson will not be regarded as the owner of the company, because Johnson and Johnson Limited is a separate legal personality from Mr. Johnson. He can apply for a loan and register in its name. So we've seen the different business organization and the implications. So it's left for you now to decide which you are going to run. Do you want to register a company? Do you want to do your sole proprietorship, you want to register a business name with, because once you're running a sole proprietorship and you decide to register with the CAC, as I said earlier, that does not mean you're separate from the business. No, it is only companies and some limited liability partnership and limited partners that tend to enjoy that uh, uh, their liability is limited to their investment. But as for company, the company is separate from the shareholders and directors. So let's look at registration of business, registration of business and non-business organizations. Why register your business? So why do you have to register your business? Registration of business is done at the Corporate Affairs Commission, whether be if a business name or company incorporation. Any business, whether small or large, will in the long run benefit from corporate and physical product registration. So let me use an example for you. Like during this pandemic or this pandemic, that's because some countries are still experiencing the pandemic, especially England, France. They are going into their second national lockdown because of the pandemic, and this affecting businesses. So for businesses to enjoy certain uh, incentives that will be rolled out by government, your business will have to be registered. And if you don't register your business, how can you enjoy such benefits? For instance, now the survival fund that want to be disbursed by the federal government of Nigeria to cushion the effect of the pandemic on small, medium, small enterprises, businesses. So tell me, if your business is not registered, how can you enjoy such benefits? Because the essence of that this thing is you must be paying your tax and your business must be registered for you to enjoy that. So if your business is not registered, you can't enjoy such benefits. So benefit from corporate and fiscal product registration, you cannot even borrow from banks, because banks will be who will lend you if your business and you want to use the money for your business, and uh, you want to borrow in the name of the business. It's not possible. If your business is not, you cannot just transact with bank, because when you want to even collect loan from bank, they will ask you to mortgage something. They will ask for a collateral, either you mortgage your house or something, any property you have. So if you don't have a company, so the benefit of even registering your business or even running a company, once you buy a property in the name of that company, you can mortgage it to a bank, and the bank will give you loan and the rest. So once you don't register your business, official transactions with bank will be difficult for you. And if you are into products that require registration with NAFDAC or certification with the Standard Organization of Nigeria, and you fail to register, the patronage may be low in the market, and these products eventually be seized. So you are being penny wise, pound foolish. You don't want to register your business. You don't want to pay taxes, and in the end, if you are into selling products that can be confiscated and destroyed, they will raid the market, they will destroy it. So that money that you would have just paid to the federal government as tax, which in the wrong long is in the wrong long, in the wrong long is going to benefit the society, because your tax will be used for better things. Then you end up not paying, you are losing on your part, and the government is also losing. So registration for tax is also an important social responsibility from both a legal and moral angle. So these are some of the reasons why if your business is not registered, or you intend to start a business and you don't intend to register, these few reasons should convince you that okay, I need to register my business. So we're going to look at small business. We're going to look at small business startup procedure. So the first thing to do, you want to start a business, you look for a suitable business name to support your business idea. Identify a suitable business location. Suitable business name, easy and related to your name, easy to pronounce and related to your line of business. So you identify a business location. I don't expect you to go and start up a business where that product you want to go into production is being produced massively in that place. So you look for something that people are in need, because business people are solvers. So you can decide to solve people's problem, be it is it they need water in that area or what. You can start by finding solutions to their problem. You are also making profit for yourself. So you register the business with CAC. Make sure you choose a name that is easy to pronounce. Don't forget your value added tax, which you remit to your this thing, local VAT office, FIRS, and your NAFDAC registration and so on. After you've gotten all this in place, you are good to go. Uh, then let's look at procedures and documents to be submitted to CAC for registration of a business name. So before I start this particular subheading, I, when we say reservation of name on CAC portal, you just don't go to CAC portal and reserve a name. You have to register with CAC. So and CAC has uh, there are accredited agents. There are agents accredited by CAC that can register your company for you. If there is a provision where you as an individual, because now we're talking of business name. Let's say you are running a business now and it's not sole proprietorship, partnership, and it's not registered with the Corporate Affairs Commission, and you want to register that business and you don't want to register it as a company and you want to make profit. So what you do is you register it as a business name, business thing. You go to the CAC portal. You as a proprietor of that business, you go to CAC portal, you register, you begin your registration. But where you, because the registration is not that easy, where you cannot register yourself, there are agents that will help you do that. Who are the agents? A lawyer, a chartered accountant, a chartered secretary. So these are people that are eligible to apply to this Corporate Affairs Commission to become agent. Like a lawyer now, like me, most lawyers you find them are agents working with CAC. So if you can't do it yourself, these are people you can contact to register your business name for you or company. So once you go to the site, you register your if you are doing it yourself, you register with the CAC and open an account. But if it is with an accredited agent, if it's an accredited agent that is doing it for you, he already has a portal. And what he will do is that he will enter the name into the portal, or you will enter the name into the portal for the purpose of reserving the name. And when you want to enter the name, CAC will give you criteria for entering the name. They will tell you, if you enter a name, don't enter a name similar to a name that is already in use. Don't enter a restricted name. Don't enter a name that is similar to another name. Don't use International Chamber of Commerce. Don't use Abuja without consent. Because once you say you want to use Abuja, you are there, you are painting the picture that your product is, there is a relationship with Abuja Municipal Council or the federal government with your product. So you need to obtain consent. So CAC will give you a list of names that are not approved, that will not be approved by them. So you enter the name of the business you want to register with the CAC, and such names are reserved for 60 days. So you have reserved for 60 days before payment. So once you pay, then that 60 days will no longer count. But once you fill the form and you fail to pay, on the 60th day, whatever you filled and the name will expire. So that name you reserve will expire. You have to re-enter it again. And so you have to complete your registration and make payment within 60 days. If not, you stand a chance of losing that name to another person. So once you just, if the name is approved by CAC, they will send a mail to you that congratulations, the name has been approved. They will give you a code. There is a code they will give you for you to begin your registration. So you enter the code, it will bring out the page and the name of the business they've reserved for you. So it's for you to enter the name of the proprietor or the proprietors or the proprietors, the state nature of the business, any means of identification, national identity card, driver's license, voter's card will serve. So you use that to enter some of your details to passport size, evidence payment or filing fees. After you've entered, you download the forms, you sign, you attach the passport, then you scan the document, then you upload it back to CAC. So once you do that, you wait for approval from CAC. An example of business names are Tayo and Tayo and Co and Global Ventures Farms. Then that is it about business names. So this also applicable to companies. But in this case of company now, company, we have different types of companies. We have private limited company, unlimited company, public limited company, company limited by guarantee. But for the purpose of this class, we are going to look at private limited company and public limited company, because these are companies that are quite common. And private limited company is a company where if you want to run a small business, want to run a small company with your family, it's advisable for you to run a private limited company. And the fact that you start with a private limited company and the company is growing does not mean you cannot upgrade to a public limited company. You can upgrade to a public limited company retaining the same name. But for private limited company, what the CAMA provides for, not this recent CAMA, because CAC are still implementing the old CAMA. So this note is based on the old CAMA, because CAC have not begun implementing the new provision of the CAMA. Because by the new provisions of CAMA, it says one shareholder suffices, one director suffices. But since CAC have not begun implementing this new provisions, and if you want to register yourself now, just like business name, you can register yourself or through an accredited agent. So you need to consider which one is more favorable for me. If you want to run a small business, it's a private limited company, and you have to have minimum of two directors, two shareholders, two directors, two shareholders, maximum of 50 shareholders or 50 directors, depending on that's the maximum you can have. Then for public limited is minimum of two directors, minimum of shareholders. Remember, the newcomer says is one will suffice, but I told you CAC are still implementing the old CAMA. They've not the new improved provisions in the new CAMA that was recently passed to law has not been CAC are yet to implement that. So when they begin, things will change. We will see a change in how to register companies. So there is no need for somebody to tell you now you must bring at least two shareholders, you must bring at least, or you must register this thing. So public companies are usually quoted as stock exchange markets and are highly regulated by Securities and Exchange Commission. A private company is more suited for small and medium businesses, as I told you, for the purpose, because I know most of you participants in this class are going to small businesses for now. Maybe you are beginning. So the appropriate company for you to register is a private limited company. So when you've gotten the name of the company you want to register, it must carry limited before CAC can approve such. It must carry limited, because you are telling, especially if it is a private limited company, you must carry that limited for CAC to even accept that name. So just like the business name I told you earlier, is either you do it yourself. If you're a director, you go to CAC site, you register, then you get a portal specifically for that registration. Don't say because you have gotten a CAC portal, you will be helping others to do their registration. No, that registration, because you are not an accredited agent, it's only accredited agents that can do for others, but you can do for yourself, for your own company. It's restricted to your own company. So after you've completed your registration with your company, you cannot do it for another person, except it's only accredited agents that can run it for different people. So you enter the name. The name is also reserved for 60 days. Remember, there are certain names that are not allowed, names that are similar to other names, names that are already used, like International Chamber of Commerce, Abuja, and the rest. These are things that you need consent before you enter them. So once you enter, let's say Mr. Johnson has entered Johnson Limited, Johnson and Johnson Limited. If it's for an example, I'm just using it as an example. So that name will be approved. If it is not approved, they will send you a disapproval note that your name has not been approved. They will give you reason for not approving the name. If the name is approved, they will congratulate you and tell you your name has been approved. They will give you a code which you enter to begin your registration. So that code will link you to the page where you enter details of the company, who the directors are, the shareholders, the minimum share capital. When we say minimum share capital, it's just an artificial violation of the company. That and CAC will only register minimum of 1 million share capital. We are not saying that you must pay 1 million naira to CAC. It's just an artificial violation of your company. You are telling CAC your company is worth 1 million naira, even though we know it's not worth, but for the purpose of administration, they are just saying put it there, 1 million share capital, which is a small company. So you are telling CAC, then you share the 1 million share capital into 1 million ordinary shares. That means different people own shares in the company. If you want to share it 50,000 ordinary shares, then you get to have almost how many shareholders. It all is all up to you. So you fill the forms. All once you are filling, you see all those things in the form. The first you see them, they are all arranged. Then you put in information on your means of identification, be it your national identity card, voters card, international passport. So you can use either. Then consent where applicable, you enter it. Then there is what we call memorandum and articles of association. Memorandum, you state the objects of the company because that is what governs the company with other people outside. Then articles of association are the rules within the company. These are the rules that govern the company with its staff. So once you put all this together, you get to know that okay, you are done your registration. Remember, 60 days. If you don't pay, you lose everything. But once you pay, there's no problem. You will not lose anything. Your registration will be there for you for as long as you wish to continue. But if you don't pay at the expiration of 60 days, the name and everything you entered will expire, and somebody will be able to use that name that was exclusively reserved for you. So once you are done, you download the forms. There are signatures to be put in the documents. So you take it to the shareholders, the directors, the secretaries to sign. So once they sign, you come, you upload, you scan the documents plus their means of identification, you upload same, then you wait on CAC for approval. So once your company is approved, CAC will tell you congratulations, your company has been approved. They will direct you to a courier company that you go and obtain your certificate from. So this is an example of fees that you pay. These are not the fees presently obtainable. We are just using this for the purpose of this class because things like fees are something that are subject to change at any time. These are policies that can change at any time. So, like for example, the registration of private companies, the share capital not exceeding 1 million, and now self states you will not even accept nothing less than 1 million. So it's not 10,000. So it's just for the purpose of this class. So if you can't do it yourself, you can contact an accredited agent. He will do it for you. All you need to do is supply information and pay money and information. That's your only tax if you can't do it yourself. But if you feel you can do it yourself, you can log in, try it yourself. But where you can't do it yourself, there are agents, lawyers, chartered secretaries they are there who are accredited with CAC. They will help you and run it. But remember, you pay their professional fees and the rest. So our final topic is going to be the law of contract. So when we talk of law of contract, basically we are talking about the the rules that principles that govern contract. And contract is an enforceable legal obligation that has been agreed upon. It has been agreed upon by parties that this is how we are going to run this business, this is how we are going to do this. What are elements? What are the features of a valid contract? valid contract. Basically, the main elements of a valid contract are offer, acceptance, and consideration. Let's consider this first before we talk about form, capacity, and legal. When we say offer, that means I'm going to use Mr. Johnson and Mr. John. Mr. Johnson has a car and he wants to sell it to Mr. John. He approaches Mr. Johnson that I have a car and I want to sell it to you. That's offer. That's another way of offer. There is another form of offer, which is you standing on the road, then a taxi is stopping for you to board. The taxi man is making an offer to you. Then when you go to supermarket, you will see things, stuffs, provisions, stuffs displayed on the shelf. In law, we call that invitation to treat. The supermarkets are not making offer to you. That is an invitation to treat. When you pick that product and you approach the cashier and make an offer to him that he should run this thing for you so that you can pay it. So that's another form of offer. You also see governments too calling for tenders. That is tenders for people to come and submit their tenders for the purpose of giving out contracts. You bringing that advertisement calling for tenders is not offer. In law is what we call invitation to treat. You bringing your company's profile and the rest, you are making an offer to the government that I want to I want that contract given to me so that let me run the contract for you. So that's offer. So you can see offer takes different dimensions. It's not offer as in always you are the one making offer. No. Offer can be in different ways. Then we have what we call acceptance. When Mr. Johnson approached Mr. John, if he doesn't accept buying the car, there can't be contract. You can't force somebody to buy something. So there must be free will acceptance by that person. It's not influenced by anything, it's not influenced by you. He accepted it willingly that he wants to buy the car. So there must be acceptance. Just like when you go to supermarket, there's always acceptance because I don't think there's any supermarket that will refuse your money. Then there is consideration. Consideration is thing of value must exchange. That means at the, by the time you pay money, that's what we call consideration. No matter how much you pay. For instance, let's say Mr. Johnson wants to sell his car for 50,000 naira and Mr. John pays as part payment 5,000 naira. The law will consider that the 18 of value has exchanged and there is consideration and such contract is enforceable. So these are just the three basic elements. Then we talk about form. Contracts can be oral, written, and they can be by conduct. Example of contract by conduct is when you enter a taxi without even saying a word to the taxi, and you get to where you want to go and you remove your money and you pay it to the taxi. That's a contract by conduct. It began by conduct. There was no word issue because you already know from spot A to spot B, this is how much I'll pay, and this car is going from this spot to so spot, and this is where this car will stop. So once it reaches the last bus stop and you remove the amount, that's contract by conduct, and it can be written too, where parties will have it in writing, and it can be oral. Parties can agree orally that they have a contract and it will be enforceable. But it is advisable for your contracts to be in writing because it makes the job of your lawyer easier, and it makes your own job in court to prove your case easier because you have something to back up your evidence. You have an evidence to back up facts that you tell the court. So it's advisable you have your contract in writing. Then we talk of capacity. A party must have the capacity to enter into a contract. You cannot go into a contract with person who is mentally challenged and underage person. This is a lunar, a drunkard, because at that period they are not mentally stable, so you can't enter into contract. But for capacity in terms of age, the fact that even though in Nigeria we don't have like a benchmark that says this is a law that says this is the age which persons can be regarded as adult in Nigeria. But we know that you when you are 18, you can vote, you can drive. So let's assume 18, and you enter into a contract with person who is under the age of 18, and the person is not up to 18 years, definitely that contract is illegal. Except the law makes provision for exception. In every general rule, there's always an exception. The law makes an exception that where that contract you enter with that minor is for his necessity, then that contract can be enforceable. When we say legality, the contract has to be legal. It must not be something illegal. Like prostitutes, you don't expect prostitutes to take a customer to court that she wants to enforce the contract they had with her. That kind of contracts are illegal ab initio from the beginning. Or a politician who hired some talks that they should go and steal ballot boxes. You don't expect that to be enforceable if he doesn't pay them their money. You don't expect them to go to court and say they want to go and enforce their right, because from the beginning the contract is illegal ab initio. So the intention to create legal, there must be intention by parties. There must be consensus. There must be agreement by parties that yes, we want to be, we want to go into contract willingly. It must not be something that influence parties to go into that contract. Then we have privity of contract. So the next thing we will discuss is privity. Privity of contract simply means only parties to a contract can enter into a contract. Let me use that example of Mr. John and Mr. Johnson selling car to Mr. Johnson selling his car to Mr. John. Let's say Mr. John bought the car eventually. Then he discovered that Mr. Johnson misrepresented certain facts regarding the car to him, and he was vexed, he was angry with such misrepresentation. What the law is saying is that Mrs. John cannot go and sue Mr. Johnson because she was never privy to that contract. She was not a party to that contract. The only person that can sue is Mr. John. So it's Mr. John that can sue. But the law makes exception to that general rule. There are situations whereby even though you are not a party to a contract, you can sue. As example of such instances is a covenant running on land, and where a third party is interfering with the contract of another person. So in such cases, you can, even though you are not a party to the contract, you can sue. Example of contract running on land is when you buy an estate from an estate developer, then you decide to sell the estate to another person. So when you sell the estate to another person, most of these estates they have covenants which you are meant to abide by, and that person you sold that property to decided to erect a fence that is up way high above what is recommended by the estate management. So in such a case, that estate management, even though the contract for the sale of that particular house was between you and that person, that estate management can sue that person for breaching its covenant. So that this is an exception to privity of contract. Then we talk of terms of contract. Terms of contract can be express or implied. Going back to still Mr. John example, he sold the car to Mr. Johnson. There's an implied, even though they've written their terms in the contract, let's say they wrote it that okay, I'm selling my car to so person, the car is in good shape. Then when Mr. John eventually bought the car, he discovered that the some major things that a car should be working in the car are not working, even though they are not mentioned expressly in the contract. The law will imply those terms. But it's advisable for you that not every term shall, those basic terms that that are in a contract, is advisable they should be stated expressly, because there are plethora of authorities that says the court will not imply terms into the contract of parties, except where such contracts are supposed to come with certain things that are to be implied with, and they fail to come with. That is only when the court will decide to make some to vary contracts of party. But mostly where parties have agreed, the courts rarely will want to vary the terms. So if you're entering contract with somebody, it's advisable you state the terms expressly. So what are those things that can vitiate a contract? We have duress. Duress is when you make somebody to enter into a contract by force under duress. You are telling him if you don't, you are threatening him with violence. If you don't enter that contract, I'm going to deal with you. If you don't enter that contract with me, maybe the person, your wife is working for that person, I'm going to sack your wife. That is economic duress. He's using economy, he's using his economy, the influence he has to make you to enter into contract. Such contract will be vitiated. Then we have undue influence, where you have undue influence can exist where there is a fiduciary relationship. When we say fiduciary relationship, there's a confidentiality relationship existing between you and the person. You trust that person that any advice that person will give you is of benefit to you. As for example, you and your lawyer, you have a fiduciary relationship. You and your doctor, you have your fiduciary relationship. You and your stockbroker, you have a because any advice he will give to you is presumed to be in your best interest. So where he decides to seize advantage of that relationship that exists between you and influence you to enter into a contract, which not turns out to be fraudulent or turns out not to be in your favor, that contract can be vitiated. And there are situations where such things, undue influence will come to play, even though there are no special relationship between parties, because maybe the party, maybe somebody decided to go and take loan in your name and he has been forging your signature and that person is related to you. Then the bank discovered that we've been giving money to this person and without the authorization of that person. So for them, and they feel it's going to take time for them to go to court, so they will just call it a meeting and say, see, if you don't regularize these loans that this your relative has been taking from them, they are going to take your relative to court and sue him for forgery. So in that case, that's undue influence where there is no special relationship. In that case, such if you execute a mortgage for the purpose of paying that loan that your relative has collected, or a nephew or a niece of yours or a relative uncle of yours who has been forging your signature, in that case, such contracts will not stand because there is an undue influence. When we talk about misrepresentation, we're talking about when you give false information at the time of before or at the time of entering the contract. Purposely, the tire is not working, and you tell somebody, the tire to that car is working properly, the AC is working properly, and everything. When he enters the car and he sees all these things are not working, then that contract is vitiated. So then we also have mistake in the sense that mistake not as mistake we used to have in our normal palace. It can be that way too, but mistake can be in such a way that Mr. Johnson, as of the time, let's say Mr. Johnson wants to sell a filling station to Mr. John. As of the time of the negotiation, the payment has they've already agreed payment. Then the the not unknown to the party that at the time they were negotiating and even before payment itself, that filling station in Wagwalada, which Mr. John wanted to buy, has been destroyed by storm. So in such a case, there is a mistake and such contracts cannot be said to be valid. So such contracts are invalid. There can be mistake in the sense that mutual mistake in the sense that Mr. Johnson has two cars, a BMW and a Mercedes, and he wanted to sell the BMW for 40,000, the Mercedes for 60,000. When he approached Mr. John thought Mr. Johnson is offering the BMW and the Mercedes for him at the rate of 50,000 naira. So even if Mr. John should pay 50,000 naira, since he has mistaken the fact that Mr. Johnson is selling the two for him 50,000 naira, such contract will be vitiated because the intention of Mr. Johnson is to sell the Mercedes 50,000 naira, the BMW 40,000 naira. So such contracts can be vitiated. Then we have discharge of contract. When we are talking of discharge of contract, we are saying that okay, parties are relieved of their obligations. They've discharged the obligations which they've entered. So in such a case, such contracts are not uh, are said to be discharged. So contract can be discharged by performance when parties have performed their obligations. Let's say Mr. Johnson has sold the car to Mr. John and the Mr. car is in good shape and Mr. John is satisfied. So So by paying him his money and him taking possession of the car, there's we say that the contract has been discharged by performance because all parties to the contract have performed their obligation. Then we have frustration, discharged by frustration. If you recall the use of that filling, the example of that filling station I gave you, where Mr. John and Mr. Johnson are busy negotiating, and even at the point of paying, there was payment, but unknown to them, that filling station has is extinct, is no longer in existence. The subject matter of the contract is no longer in existence. Then we will say to say that the contract has been discharged by frustration. Then we have fundamental breach. Let's say you order for an iPhone from Konga, then Konga decides to supply HTC to you. In that case, there's a fundamental breach of the contract, and in such a case, that contract cannot be said to be valid. And in the end, the contract is discharged, and contract can also be discharged by mutual agreement. Parties can just decide that, okay, uh, let's just discharge the contract. We don't want to go into the contract anymore. We are okay. We are okay. So in such a case, that contract can be said to be discharged manually. And finally, for today, we are going to talk about remedies for breach of contract, where parties have entered into a contract and one of the parties breaches either term of the contract, and a party breaches a term of the contract. What are the remedies available to you? Mr. John and Mr. Johnson want to enter into contract, and Mr. Johnson breaches part of the contract. Like we talk about the cars, the AC and the rest not working in the car after selling the car to him, while he has already made a presentation to him that that car, the air condition, everything is in perfect shape. What are the remedies available to him? One is damages, which is a monetary compensation given to him. Instead of returning, he can return the car, return his money for the car, and in addition, add money for certain inconveniences he has suffered for buying that car. So he's entitled to compensation. We have what we call specific performance. That is when the court will order a party to perform his obligation. Let's say Mr. Johnson and Mr. John entered into a contract for the supply of 50 bags of rice, and Mr. John paid upfront full he made full payment to Mr. Johnson for the 50 bags of rice. Mr. Johnson ended up supplying 40 bags. Mr. John can go to court and tell the court that he wants that uh, the court to make Mr. Johnson complete the contract for him. But mostly specific performance is given when damages are not sufficient. When damages will be sufficient, the court rarely grants specific performance. And where the court grants specific performance mostly is when it comes to land transactions. Then we have ratification. Ratification is just the court changing terms of the contract. Okay, you are supposed to supply 50 bags and you supplied 30 bags, Mr. Johnson. So now that you've supplied 30 bags, Mr. John accept 30 bags, he's going to refund you your money for the remaining bags. So that is the court ratifying the contract. Injunction is when they are stopping somebody from doing something. Injunction can be perpetual, entering perpetual, and can be interlocutory, and can be mandatory. Sometimes there is what we call a law mandatory injunction, where you ask for a mandatory injunction asking a party to do something. So all these cases are there. Then we have what we call quantum merit. That is according to the services I offered to that person, I'm entitled to payment. For instance, a taxi carrying you from uh, area one and you are coming to Wuse, then the car stops at Bega. The law is reasonable for you to pay him from from area one to Bega, since he has offered a reasonable service to you. Then we have rescission. Rescission is when the court decides to end the contract, and you tell the court you don't want the contract anymore. You should just rescind the contract, and if you've made payment, you should return your payment to you and the rest. So that's it. The contract has ended. So thank you very much. We've come to the end of today's class. I believe you've learned something today. So if you have any question, uh, any question, contribution you want to make. Now is the time to make. You can unmute your mic, unmute your mic and ask your questions or uh, make your contributions, questions, contributions, any observation you want to make. Now is the time to do that. You unmute your mic and answer a question. Is there something I said that you don't understand or you want me to explain more? Or is there something you want to ask? Now is the time for you to do that. Unmute your mic and ask your question. Is he going to say okay? Okay, in the absence of any question, contribution, or comments, I'm going to hand you over to the coordinator for his final. Okay, somebody is raising his hand. Mr. Hassan Ahmed. Can you unmute yourself and ask your question?
Myself, sir.
Mm.
Hello, sir.
Hello, I can hear you.
Hello, are you hearing me?
I can hear you, sir.
Yes, I said, sir, if somebody has a sole proprietorship registration form with the CAC
Yes,
and
sir.
he did not even start operating the business by way of paying his truly bad, and now he joined this cadre program. So that sole proprietorship, can he use with it, or he will just abandon it and proceed with this program which we are doing here? That is my question, sir.
Okay, first of all, when did you register the company?
I registered it in 2017.
Okay, the business name is 2017. It's a business name, right?
Yes.
Okay,
Yes,
so
it's business name.
it's what we call annual returns. You get it?
Mm.
So
Yeah.
2017, you are not you are supposed to pay annual returns for 2017, 2018, 2019, then this 2020. You get it? 2020. Then
Okay.
there are
Yes.
penalties attached to the annual return pay. So if you want to still use that business
Okay.
name, you have to pay for that annual return and the
Mm.
penalty. And it might be that the object or the nature of the business which you registered with that business name will not be the same with what you want to do now. So you might change it, but this will take.
Yes.
You can change it. You can pay your annual returns, change the nature of business you want to go into, then
Okay.
maintain that other business name. But if you feel it's going to take time, you can go ahead and register another business and abandon the one you registered earlier. But the implication is that if you abandon that one, there will be a time when CSC will come and deregister it because it's no longer a going concern as far as they are concerned. So
Okay.
that is the options available
So
to you.
so
Either
so
you
so
pay.
for instance, if now I want hello, sir.
Yeah, I can hear you.
If now, for instance, I want to pay the penalty, yes, I of the to am I to follow?
Mm. Hello, sir.
Which
You said.
I say if I want pay the penalty and the due
uh,
of 2017 to
2020.
2020.
Yes.
Where should I go to?
Then this time you CAC and you have to contact a lawyer that will do that for you. But it's post
Okay.
incorporation, so you can't do it yourself. So you contact a lawyer. So he'll put you through. He'll tell you,
Okay.
and he'll charge you for his professional fees for doing that. With the CAC. Everything is with the
Oh,
CAC.
all right.
But if it will take time,
Hello.
you can just
Oh,
register another business name. Okay,
all
thank
right. So, for instance, now as we are doing, as we are undergoing this our
you.
program now, I know definitely this our Kedron will open a business name for us. Can I register that name and proceed with it at EIB? I am to change another business name.
If you want to use that name you are using, which
Uh,
is already registered,
mm,
if you want to use it to
mm,
register
mm,
another name, if to register another business name, it's not going to
mm.
be possible because already that name is in use.
Okay.
So you can use another name.
Okay.
You can use another
Okay.
name
No
to
problem,
open
sir.
another business. Since the nature of the
All
business
right.
is not similar with the one you registered earlier. You get it?
Yes.
Okay, that's
Okay.
hmm.
All right. No problem. Thank you, sir. Thank you for patient for and
No
well,
problem.
I'm very grateful with this your lecture, sir. Thank you, sir.
Welcome. So
All right.
Miss Glory. Sorry, I don't know whether it's Mrs. or Mrs. But Glory,
Yeah,
unmute your mic and ask your question.
good afternoon, sir.
Good afternoon, ma.
Yeah, network has been a challenge, but under the remedies for breach of contract, number 5 is not very clear.
Number
Quantum, yeah,
quantum merit.
yes, I
Where
don't know.
what quantum merit is Latin word. What is simply saying that you are entitled to your to 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 the benefit or whatever services you offer to somebody. Let me give an example. You get it. Quantum merit is simply okay. You offer services to somebody. Let's say you are you are you are you are building something for somebody. So you reached a point, and the person said he doesn't want your services anymore. You know you've expended energy and money to do that work. So what the law is saying is that you are entitled to payment to the point of the services you offered. You get it? Let's say for example, I use the example of a taxi for instance. You entered a taxi from Beggar and you are coming to Lifecam Junction, and the car suddenly stops at it stops at Jabi. So what the law is saying is that that taxi driver carried you from Beggar to Jabi, even though you are going to Lifecam Junction. You're supposed to pay him for that services he offered you from Beggar to Jabi. If it is 100 naira, you pay him his 100 naira. He's entitled to that. So that is what quantum merit is. That is, you are entitled to reasonable value of services you've offered. You are entitled to compensation for the reasonable value of services you've offered. I don't know whether you still get me, or I should use another example.
Get it, but isn't that a breach of contract? I was going to Lifecam, not Jabi.
Something happened when he did not complete the contract. The car developed a fault. So what the law is saying that is you, or it's not him that decide that he won't carry out the contract. It's you that is telling him to stop. You get it? Or a problem has developed, or is you that is telling him to stop. You get it? It's not like it's not if it is if he is the one, or let's say the person that contracted you that decided to say that I will no longer do it, then that is where we'll say there is breach. But where it is not his own fault or something, then he's entitled to quantum merit. Hello? Do you get me now? Hello? Hello, ma. Okay. The network is bad. I don't know whether anybody has any other question before she who? I don't think she has. Is her mic is on. Um, sorry. Does anyone has any contribution? In the absence of any question, contribution, thank you everybody. So I will now hand you over to our coordinator for the closing remark. Thank you very much for your patience. Okay, there will be quiz. Sorry, there will be post-lecture quiz after the coordinator's final comment. So you wait and write your quiz. Thank you very much. Sorry, just the quiz has been posted, so you just do your quiz while you prepare for the last module for the day. Thank you very much. No more final comments from our coordinator. Just do the quiz, 5 minutes, then you wait for the next module. Thank you very much.